Everybody say, say, how can I express my gratitude for all the many things you've done for me? Words are not enough to say thank you. So Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things you've Father, you done for me, yeah. Words are not enough to say thank you. So Lord, you're my everything. Say, I call you Zion. You're my provider. I call you me.
It is October, and we are in the very first week of it, the very first Saturday of October 2024. Hello, this is BWTV, and we bring you the community and the law. Did you know that you can challenge a UK visa refusal decision? You didn't know. I didn't know, but today we're going to both find out. BWF Solicitors is bringing us the community on the law, and it's live. Next. Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208-493-7345. Or you can send a text 07950-422-780. It's The Community and the Law. My name is 𝗖𝗢𝗠𝗠𝗨𝗡𝗜𝗧𝗬, and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
It's a Saturday afternoon. Good afternoon. Welcome to another edition of The Community and the Law, brought to you by BWF Solicitors. Now, for the next 2 hours, we're going to have a very lively and lovely discussion where you have a lot of things to put in your arsenal when it comes to knowledge, especially when it's about the law and immigration issues here in the UK. My name is 𝗖𝗢𝗠𝗠𝗨𝗡𝗜𝗧𝗬, and thank you for having faith in us to stick around and also join us in our discussion. Did you know that you can challenge a UK visa refusal decision? I know the answer is no, I didn't know. And we have been told several times that when you are refused a visitor's visa, you cannot challenge. Well, this afternoon, we're going to find out if it is possible to really challenge such a decision. And if you challenge it, what do you do? Do you go for an appeal? Do you apply again? Do you ask that they review it one way or the other? We will be looking at that. Our resource person this afternoon, coming from BWF Solicitors, is lawyer 𝗖𝗢𝗠𝗨𝗡𝗜𝗧𝗬. He will be leading us in that discussion. But prior to that, we shall be having our updates that we do as usual, and then also to make a few announcements here and there. So if you just joined us, thank you very much. First of all, like the page, share, and also show us that you are here in the comment section down below, and also invite people to come and join us. It's the community and the law. Now let's pick up our updates. There are several updates, and one is about fee waiver. Now, fee waiver is the situation where you apply to the Home Office to say that you cannot pay the application fee and that they should take it off so you can make your application free of charge. People use that, and it has come to become common knowledge maybe, to say that people try to use that to buy time. There is a danger in that. Now listen to this. Applications for fee waiver are only intended for those making human rights applications. If someone makes a fee waiver application where they have no intention of making future human rights applications, it may constitute false representation. If you've been following this program, you would have realized that if you make false representations, which in the ordinary person's parlance, if you lie to the Home Office, there are several dire consequences. False representations really represent a general ground of refusal in immigration decisions, and as such, there can be serious consequences for an applicant if they are found to have made such representations. Fee waiver, I explained it earlier on, and I know Lawyer Charles Asma will give more insight into that. But you're asking for the Home Office to take away the fee so you can apply free of charge. If you make a fee waiver application where you have no intention of making future rights, human rights application, it may constitute false representation. And I've reiterated that if you make false representation, it could lead to some serious consequences. Now, this is what I've quoted from paragraph 9.7.1, part 9, Immigration Rules, AA Nigeria 2010, England and Wales Courts of Appeal ruling 773. So that's by that. Yes, I will be touching on all of them, and when I come back to Lawyer Charles Asma, I'll ask him to give us further explanation of that. So be mindful that if you are applying for a fee waiver, remember it is only intended for those making human rights application. Thank you for that. So take note of it. If you no biometric appointments between now and 15th October unless there are cancellations. Now, there's an announcement I mentioned earlier on that I was going to make some few announcements around the law. According to UKVCAS, messages that have been received on X, there are to be no more biometric appointments released on the UKVCAS unless other applicants cancel their appointment. While it is now possible to register and book appointments with TLS Contact, their contract does not begin until the 15th of October. So there are effectively no appointments between now and the 15th of October. It seems that everyone submitting applications now has to wait until 15th of October or beyond for their processing to commence. This means that regardless of whether they have paid for priority or super priority processing services, applicants will still have at least 2 weeks to wait before their processing begins. So remember, if you have put in that application, if you submit it and you have not received the notification that is being processed, it's because that the TLS contact, their contract is not beginning until the 15th of October. We're not too far away from that anyway. Today is the 5th, so we have 10 more days to go. Note that as these are in-country applications, applicants cannot travel outside of the UK without withdrawing their application. That will be stressed and explained later on. Now let's pick up the next one. Replacement BRP service closed on 26th of September 2024, and no more BRPs issued from the 31st of October. On 26 September 2024, the Home Office amended various guidance documents to reflect the withdrawal of the replacement biometric resident permit, that's the BRP service, on that day as part of their ongoing move to fully digital immigration status from the 1st of January 2025. There was no separate announcement to this effect. Details of this development and of the separate email sent to stakeholders on the same day below. So you may have received an email like what I'm going to read. The closure of the BRP replacement will affect the following cohorts. Non-EEA national family members of EEA nationals whose biometric resident card BRC has expired. Persons whose BRP or BRC has been lost or stolen. And the other bit is persons whose relevant personal details on their BRP or BRC have changed. That is your name, your gender, your nationality, or facial appearance have changed significantly. You will be affected. Listen, BRP holders will already have a UKVI account, but BRP holders should create one in order to access an e-visa. They can use their passport and last visa application reference number to create their UKVI account, but they should also still report the loss or theft of their BRP. Now, if you're having challenges creating your e-visa account, you can contact BWF Solicitors and they will help you out. 0208-493-7340. That's the BWF Solicitors telephone number 0208 493 7340, and they will help you. So trust BWF Solicitors will help you with all these things. Before I go on, let's do some celebrations here. I have my very own co-presenter, who's also a caseworker at BWF Solicitors, celebrating her birthday this very October 2024. Happy birthday to you, Pamela Oakley. We're wishing you a fantastic day and a full month filled with joy, laughter, and other things you love. Your hard work, positive attitude, and dedication are truly appreciated, Pamela. And we are so grateful to have you on our team. May the year ahead be filled with new opportunities, success, and happiness. Listen, enjoy your birthday, enjoy your birth month. We so cherish you. We so appreciate you. Happy birthday to you, Pamela. Continue to be you. Thank you very much. Okay, now let me bring on Lawyer Charles Asma when I've done all my announcements and done my updates, so I could have the way all clear for Lawyer Charles Asma to join us live on the program. Lawyer Asma, good afternoon. I think you must have been muted somewhere. Check your mic.
Good afternoon.
Muted. Yeah, good afternoon. Yeah, I can hear you now. How are you doing?
Very well. How are you doing?
Yeah, I'm good. I'm good. By the grace of God, we're all doing fine. Everybody is well. First of all, I want you to join me celebrate our very own Pamela, who has celebrated her birthday. In fact, it was earlier in the week, and today we have had a chance to do that. So let's do thank yous and birthdays to happy birthday to Pamela as well.
Yes, Pamela has been very instrumental in ensuring that clients are happy, they are getting the best for the instructions they give us, and at the end of it, they are getting positive results. So, Pamela, very, very hardworking, positive attitude, as the birthday message rightly put. And so we joined the many clients we have, the staff of UW Solicitors, staff of UW Solicitors Ghana, UK, friends and family to wish you well. It's our prayer that you continue to do the best and make clients happy. And we believe that all your wishes will definitely come true. Once again, congratulations.
Well, happy birthday to you once again, Pamela. Yeah, no, that's right. Yeah, there a few announcements coming up about the biometrics. People pay for the enlisting and all that, and now people can do that until the 15th of September. Would you lighten us on what's actually happening?
Right. So we have. Okay. So we know that it used to be the case that we'll go to the post office. Before that, very good afternoon to you, viewers and listeners. Once again, opportunity to meet and learn and develop. Wherever you are present. So before you book up, you submit your application and you get an appointment to go to post office to enroll your biometric data. This change to where the contract was given to an agency called UK VCAS, that's the United Kingdom Visa Service Center. There's also another service center outside the UK, which is overseas entry clearance processes, and that is called TLS, Contact Center. So the TLS Contact Center is for overseas, and UK VCAS is in country. What has happened is that the contract for UK VCAS has been given to TLS Contact, so that from 15th of October 2024, all enrollment processes, UK visa application enrollment processes will go through TLS contact and no more UK VCAS. So we are in a transition period. And so the contract with TLS contact center will begin from 15th October. So from now till 15th October, even though you can book using TLS contact and all that, nothing will take effect. Process cannot go through because contractually you cannot have your data processed or enrolled. And so you can book, but nothing will happen. And so we are in a transition period. So when you go online, you will see that it will ask you, are you enrolling before 15th October or after 15th of October? If you say after 15th October, they will transfer you to TLS. And if you say before 15th October, you go through UK VCAS, but the process is very slow and therefore it's stalled. So there's no way you can progress with appointment booking. So simply, no one can book appointment and go for biometric until after 15th of October 2024. And the reason is what we have shared.
Okay. Now, does it then affect people who probably would want to travel prior to that? Do they have to withdraw the applications, or if possible, they will have to wait until after 15 where they will get that? Are the two related?
I mean, regardless of this situation, if you put in an application and you felt that you wanted a priority so that you can travel and you can't have it and you decide to travel because you still have leave, and by the time, meanwhile, you have put in the application, once you travel, of course your passport is still with you, but once you are outside and your visa expires, there's no way you can travel back, and you can't tell them that I had my application and I was waiting for my biometric, so I just dashed out to get back in so that I can have my appointment. That would be very difficult, so let's not take the risk at all.
Okay. Then and there's also this one, this announcement that came up that the BRP service from the 26th of October is closed, and from the 31st of October, 26th of September, I should say, and from the 31st of October, no more BRPs will be issued. What's happening?
We know that from 31st, actually from the 1st of January 2025, there will be no more BRP cards
Hmm.
because everything is gone online, e-visa regime. What it means is that when people apply to be issued with their card, imagine you apply today and you are going to be issued with a card for up to when? 31st of December 2024.
That's right.
You're paying for it. It doesn't make sense, does it?
Hmm.
And so there's now a cutoff period where you cannot apply because it wouldn't make administrative and operational sense for any card to be issued now that there is a transition window or period. And so if you misplace your card or whatever it is, I'm sure they will have in place the approach to those who may lose their card and so on and so forth. But what we are saying now is make sure you have enrolled your you have linked your visa to your passport or card
Hmm.
so that at least once you have your e-visa running, regardless of what happens to your card, you are safe. If you haven't done it, do it now, even if you have 1 day for the card to expire. If you have done it and you lose the card, you are okay because you had your e-visa already active and you can still access your information online. So it's as good as the card expiring on the 31st of December.
Okay. One thing that's just crossed my mind. So if I have my e-visa, which has my biometric details and everything, can I then continue to use that to generate a share code? Are they linked one way or the other in any way at all?
So when you go on the portal, you
Mm-hmm.
have your UK immigration status information.
Mm-hmm.
the type of visa you have, and when it expires. And if you scroll down, you have your picture, and it will tell you create a share code. You can then use the same portal to generate a code.
Okay. All right. Right. That clears it. Thank you very much. And if you have any questions, you have any queries, you would want to get more details, you can call BWF Solicitors on 0208 493 7340, 0208 493 7340, or 077 127 61884, 077 127 61884. Or you can Charles Asma has his number here. Let me quote it out for you: 07947636037, 07947636037, and they are happy to help you with that. Now, there's another bit about fee waiver. That's our nugget for earlier in the week. Laura, Asma, we're saying that fee waiver for buying time and its relationship to misrepresentations and, in our ordinary parlance, lying, and some of the consequences it will have. We need some details into this as well, please.
Thank you very much. So the key thing is the intention for the fee waiver.
Mm-hmm.
So we are going to juxtapose the intention and the action that follows on from the fee waiver.
Yeah.
Fee waiver is a human right opportunity wherein somebody is making an application for human right, i.e., family life, private life, Article 8, or could even be that it falls under um, humanitarian grounds, say such Article 3, where the person feels that they don't have family, but they have other special medical or circumstances that moving them from the UK will make their life very, very hard, what we call insurmountable obstacle. So human rights, Article 8, 3, 2, 5, what have you. Once you decide to make that application, you get your fee ready. Question is, what if my fee is not ready because I don't have the money to pay?
Mm-hmm.
Currently, the fee is £3,845.50. If I don't pay, I can't. And if I can't, that means I cannot exercise my private life right or my family life right, which falls within the human rights. Either you take it from the European Convention on Human Rights or you take it from the Human Rights Act 1998, which is a creature, or let's say, a creature of the European Convention itself. You have a position. The question is, if you cannot afford, and they tell you that because of the fee, you will not be able to progress with the application, your rights are being denied.
Okay.
And because of that, it becomes a constitutional matter, constitutional law matter. When we say constitutional law, anything that borders on how society is governed, how public bodies are supposed to carry out their activities, anything that contravenes that from that and other people's rights will be an issue to be dealt with. So the government started and realized that if people's rights are going to be affected by way of this position that pay before you apply, then we are going to be in trouble because people will be right to take us to court to say that we have made a law that affects their human rights. And because human rights are entrenched rights, you cannot do anything that affect those rights. So if you look at Section 6 of the Human Rights Act 1998, it says that any action, behavior, conduct that comes from a public body which affect human rights is a contravention of that human rights, and that law will be incompatible with the European Convention or the Human Rights Act. And therefore, fee waiver, the fee is also set in the law that you must pay before you submit. And if I can't pay and I can't submit and my rights are affected, I can take the government to court and I will cite Section 8 of the Human Rights Act. So government said that that's fine. We are not going to make it open for everybody because some people may wish to pay. So if you cannot afford, come to us and tell us why and give us the evidence and we'll waive it for you. Hence, fee waiver.
Okay.
Now, we said the fee waiver is only for human rights applications, family life or private life. Let's assume our case study person or subject A. A is currently working for the the company, the employer.
Mm-hmm.
A is on a skilled worker route. A has received a letter that your company's license has been taken away and so you cannot continue. You have 60 days. A is looking at other options, including finding a new job or resorting to any other legal route.
Mm-hmm.
A then says that, right, a company has promised me, and therefore I am going to make an application for fee waiver to hold the position. In other words, to protect my visa or to buy time, as it's quoted in this, to buy time. If you are going to buy time with a fee waiver, the question is the intention of the fee waiver for human rights application or for work application, visa application?
Mm-hmm.
If it turns out that the intention of the fee waiver was for skilled worker application or any other application apart from human rights, then there's falsehood somewhere. I don't know if you agree with me.
Yeah, I
So
do.
you have to prove that there's no falsehood. How do you prove it? Right. You put in a fee waiver application, fee waiver application decision is made, and you are told that your fee waiver is rejected. Pay the fee and submit the application. At that point, you cannot make another fee waiver application because you don't have leave to be able to make another fee waiver application. And so you have to pay and submit the original application intent for the fee waiver, which is maybe private life or family life. But if you decide that you are not going to put in that fee waiver, but you are going to move on to your main application, which is skilled worker application or whatever, then the question is, why did you make the fee waiver? Is it just to deceive for your own good?
Mm.
It turns out that that is the intention, then that would be misrepresentation in another respect. And
Okay.
that will come up when you are making another application in future. That can come up and they can tell you that you made the application for fee waiver knowing that you did not intend to make a human right application. But if you made the fee waiver application, it was rejected, you paid 383,845 pound 50 pence to submit the application, or the fee waiver voucher was given to you and you used it, you have made the application. So the question is, have you satisfied the intention for the fee waiver application? Yes, because you have continued to make the substantive application, which is private life or the family life. So you are okay. If before that human right application is decided, you have another application opportunity and you put in a new application, for example, skilled worker or anything, they will ask you, do you have an application already pending?
Mm-hmm.
You say yes. They will ask for the existing application code. You put in the UN code number, and the new application you are making takes over from the existing one. That means you are now varying the existing application to a new one. That is acceptable. But if you decide to abandon the fee waiver application itself and you move on to something else, then it appears that your original intention was to buy time for your personal interest and not necessarily moving through the procedures or the law or the rules itself.
Okay.
That will come up again in future. And that's paragraph 9.71 Part 9 says that if it turns out that there's falsehood or misrepresentation somewhere, then it can be used against you. Again, there's case law on that basis.
So, application for fee waiver, as lawyer has explained, are only for those making human rights application. So, if you do not intend to make that application where after the decision has been made on your fee waiver application, please don't try, because it could be considered as misrepresentation. Then that could go against you, and those consequences could come back biting you. We're live on BWTV and bringing you the Community and the Law, brought to you by BWF Solicitors. BWF Solicitors are trusted partners when it comes to the law, especially immigration issues here in the UK. You can visit them on the 4th floor of the Anna House, 214 to 218 on the Tottenham High Road, Seven Sisters in North London. They work Monday to Friday between 9 a.m. and 6:30 p.m. Please visit them, go contact them, send them your issues, ask them to help you to put in all your applications. And I tell you, when it comes to the law, we don't have any other challenge apart from BWF Solicitors. BWF Solicitors 0208 493 7340 0208 493 7340. They have an office in Ghana, and you can reach them on 055 589 5959 in Ghana. 055 589 5959 in Ghana. And the emergency number is 077 127 61884. 077 127 61884. And our resource person this afternoon, Lawyer Charles Asma, is on 07947 6360 37 07947 636037. Now let's take a break, and I'll say thank you to BWF Solicitors. And when we come back, we will be answering the question about how to challenge a UK visa refusal decision. Is it possible? We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Our trusted community partners when it comes to the law. BWF Solicitors is bringing you the community and the law. And this afternoon, we're looking at one very interesting topic and question. I'm asking, did you know that you can challenge a UK visit visa refusal decision? I'll be getting you into that very soon. Nana, I'm Obia, James Noah. You all watching with us. Augustina Jarim, hi. Thank you very much. Tilly Duma, thank you. We are inviting and asking Abna Obnewa Asantewa Papebi. If you joined us, welcome on board. Tilly is asking people to share when they come on board. So announce your presence when you are here with us. We're live at BWF Solicitors YouTube, BWF Solicitors Facebook, BWTV Facebook, BWTV YouTube. Gerald Agbat, you're watching with us. Thank you. We have Kofi Nat, Nana Ajiman Opambo, Wumpini Adam, and a host of others. On our YouTube channel, those of you watching with us from there, thank you very much, and we do really appreciate your presence and your time. So share the link and also like the page for us so the algorithm will look good, and we will have the motivation to come up with content every now and then. Did you know that you can challenge a UK visit visa refusal decision? Layasma, are we able to do that?
Thank you very much, viewers and listeners. So today's conversation is very important because it's one of the scary areas of immigration activities in terms of visa application, entry clearance. So what we're going to do is to look at a couple of scenarios, so practical bits, as we always do, so that we have the perspective set out. We also make reference to the guidance that underpins this whole conversation. So you are making an application to enter the UK to visit, and a visitor is somebody entering with a view to return immediately. So once you make an application, it's open to the caseworker to give you or not to give you. And what you are looking at is to prove to them that you return once you've been granted. So that's what we call returnability test.
Okay.
It's very difficult to pass the test because it's up to the marker, the examiner, or the caseworker in this case to agree or disagree with your claim of visiting the UK. So let's look at the guidance for visitors. Producer, if you could please assist us. Right. So we have the immigration rules, Appendix V, which is for visitor. We go down to 3 types of visitors. So just up a little, 3 types of visitors.
Okay, yeah.
So standard visitor. So Bragoku, please do us the honors.
So yeah, there are 3 types of visitor. We have the standard visitor, the appendix visitor, and marriage or civil partnership visitor. The standard visitor says for those seeking to undertake the activities set out in appendix visitor. So permitted activities, for example, tourism and visiting family, usually for up to 6 months. A standard visitor may apply for a visit visa of 6 months to 5 or 10 years validity. However, each stay in the UK must not exceed the permitted length of stay endorsed on the visit visa, usually 6 months. The next one is the marriage or civil partnership visitor. That's for those seeking to come to the UK to marry or form a civil partnership or give notice of marriage or civil partnership. Then there's the transit visa or visitor, so to speak, for those who want to transit the UK en route to another country outside the common travel area and who will enter the UK for up to 48 hours by crossing the UK border unless appendix visitor, that is transit without visa scheme, applies. Lawyer Charles. Okay, now let me take another quick break, and then
Yes.
we will come back. Are you here? Okay, good.
Yes. So you can see that we have three main categories: standard visitor, marriage partnership visitor, and transit visitor. Transit visitor, we know that you are transiting, going elsewhere, you are just passing through. Marriage visitors will come in to the UK to marry, and we call fiancé leave to enter. Standard visitors are all of us: family visiting family, friends visiting friends, and others coming in for training programs, events, and so on and so forth. Right. Now, if we go down, it tells us that, please, let's go to the eligibility, the main thing. Yes, so if you stay there, entry requirements, eligibility. So to be able to be eligible, you have to meet the following requirements.
Mhm.
So, Brad, if you help us with
Okay, so
V01.
the decision maker must be satisfied that the applicant, unless they are applying for entry clearance or permission to enter as a transit visitor, meets all of the eligibility requirements in V4.2 to V4.6, and that they meet the specified additional eligibility requirement where the applicant A is a child at the date of application. They must also meet the additional requirements at V5.1 and V5.2, or the visitor is coming to the UK under the approved destination status agreement. They must also meet the requirements at V6.1, or the visitor is coming to the UK to receive private medical treatment. They must also meet the additional requirements at V7.1 or to V7.3, or the visitor is coming to the UK as an organ donor. They must also meet the additional requirements at V8.1 to V8.4, or the visitor is coming to the UK to study as a visitor. They must also meet the additional requirements at V9.1 to V9.5. Is an academic seeking a 12-month entry clearance. They must also meet the additional requirements at V10.1. Or is coming to the UK to undertake work-related training. They must also meet the additional requirements at V11.1 to V11.3. Or then the person is coming to the UK to marry or form a civil partnership or give notice of intention to marry or form a civil partnership. They must also meet the additional requirements at V12.1 and V12.2. Next bit, the person is coming to the UK to undertake permitted paid engagements. They must also meet the additional requirements in V13.1 to V13.3. Or J, the person is applying for permission to stay as a visitor. They must also meet the additional requirements at V15.1 to V15.4. Lawyer.
Good. So it tells us that apart from V4.1 to V4.6, which applies to every visitor, there are specific reasons for entering the UK, and that is
Mhm.
A to J. If you go down, we have what we call genuine visitor. That's very important. Who is
Mhm.
a genuine visitor? If you look at the test, that's 4.2. Remember, it says that you have to meet 4.2 to 4.6. So let's look at 4.2. What does it say? Just
The
the first.
applicant must satisfy the decision maker that they are a genuine visitor, which means the applicant will leave the UK at the end of their visit and will not live in the UK for extended periods through frequent or successive visits or make the UK their main home. And the person must be genuinely seeking entry or stay for a purpose that is permitted under the visitor route as set out in Appendix Visitor Permitted Activities and at V13.3. And then the person will not undertake any of the prohibited activities set out in V4.4 to V4.6. And the person must have sufficient funds to cover all reasonable costs in relation to their visit without working or assessing public funds, including the cost of the return or onward journey, any costs relating to their dependents, and the cost of planned activities such as private medical treatment.
Go to
The applicant
4.3,
must
please.
show
Go to
that.
4.3.
Okay.
In assessing, yes.
4.3 says, in assessing whether an applicant has sufficient funds under V4.2E, the applicant's travel, maintenance, and accommodation may be provided by a third party only if that third party A has a genuine professional or personal relationship with the applicant and is not or will not be in breach of immigration laws at the time of the decision or the applicant's entry to the UK as a visitor. And C, can and will provide support to the applicant for the intended duration of the applicant's stay as a visitor lawyer.
Good. So it tells you that 4.2 to 4.3 is clear who a genuine visitor is. And most people will be refused on the basis that they do not pass the genuine visitor test. In that, they are either going to tell them that they don't have sufficient funds, or they haven't proven that the sponsor or the person giving them their bank statement or accommodation has genuine relationship with them, or something is missing generally. And how do you prove that? You have to look at what you are doing in your country as against what you are coming to do. There's a bit that they mentioned must not. So if we once we are going through 4.2, it reads that some people will be coming to the UK often and often and often. If you look at C, is genuinely seeking entry or stay for the purpose that is permitted. Okay, so if you look at where it says that the person will not be visiting the UK frequently. Some people will have the visa, they go back, but they will keep coming. There have been instances where people have had their 2 year or 5 years cancelled because every 3 months they are coming. And it makes it difficult for them to believe that this is a genuine visitor. But this is somebody who is applying for the first time and they think the person is not a genuine visitor, in that they don't have sufficient funds or they are not doing anything meaningful in terms of commitment in their home country. And so the suspicion is that once they arrive in the UK, they may not return to their home country. So it's possible that somebody will be refused on the basis that they do not meet the requirement of a genuine visitor. If that happens, what do I do? All right, we are going to look at a sample refusal letter and we'll see what the caseworker will tell you once your visa is refused. And that will be the basis of the conversation. Producer, please, can you share with us the sample refusal letter? Just go straight to the last page. Next step. Straight to the last page. Next step. Right. Bravoku, what does it say?
In relation to this decision, there is no right of appeal or right to administrative review.
Right. Now, let's go up to the decision, the reason. So there, decision, yes, that bit.
You have applied for a visa to visit the UK. In deciding whether you meet the requirements of Appendix V of the immigration rules for visitors, the website link is given. It says, I've considered your application, your immigration history. I've refused your application, that's a decision, for a child visit visa because I am not satisfied that you meet the requirements of paragraphs of V4.2 and V5 of Appendix V, Immigration Rules for Visitors, because you said you will visit the UK with your parents. Your parents' application has been refused, and the reasons for their refusal has been detailed in refusal notice sent separately to them. As you are dependent on your parents to support you and are reliant on the same supporting documentation to support your application, I'm satisfied your application should be refused for the same reasons. I'm therefore not satisfied that you are genuinely seeking entry as a visitor and that you intend to leave the UK at the end of your visit. Your application is therefore refused under paragraph V4.2A and C. I am not satisfied that you have sufficient funds to cover all reasonable costs in relation to your visit. The application is therefore refused under paragraph 4.2E. In addition,
Right. Yeah, please go ahead.
you were dependent on your parents for your travel to and care and reception in the UK and have not demonstrated that alternative arrangements have been made for you to travel without them. Your application is therefore refused under paragraph V5.1. Well, how many reasons? V4.2, V5, V4.2A and C, V4.2E, V5.1. Couldn't it have been just one reason and that's it?
Well, so this has been refused under V4.2, genuine visitor assessment.
Okay.
So A, C, and E. E is about not enough funds. A, C, talking about what they are coming to do is different. So, producer, take us to the eligibility A, C, and E quickly, please. Yeah. So, Brakoku, what does 4A say? Eligibility. Producer eligibility. The guidance. Yes. So A.
The person is a child at the date of application. They must also meet the additional requirements at V5.1 and V5.2.
Producer 2. 4.2. Producer 4.2. Genuine, yes, 4.2.
The
Yes.
applicant must satisfy the decision maker that they are a genuine visitor, which means the applicant will leave the UK at the end of their visit.
Good.
And
So
will not
this
live in
person,
the UK for extended periods, yeah.
so this person, they didn't believe that they will leave at the end of their visit. And C, they also quoted C as the reason. What's C?
The applicant must satisfy the decision maker that they are a genuine visitor, which means the applicant is genuinely seeking entry or stay for a purpose that is permitted under the visitor route as set out in Appendix Visitor, Permitted Activities, and at V13.3.
Right. So leave it. So they think that when they come, they will be doing something else other than visiting. So that is A, C, and also they used E. E is about
yes.
finance, the fact that they didn't have enough funds through
That's
their
right.
parents. Right. And they also used quoted V5. So either way, they believe that this is not a genuine visitor and therefore it's likely they will not return. So the parents were refused and the child also refused. Question is, I don't have the right to appeal. I don't have the right to administrative review. So what do I have? If I can't appeal and I can't ask them to review, what can I do? Nothing, right?
Mm-hmm.
But
Because
today
they said they have refused it, and that's it.
that's it. But today we are saying that you can.
How can you?
Yes, and that's the conversation. So we are saying that this person is applying to come to the UK to visit.
Mm-hmm.
Probably they are visiting family. If you look at the eligibility, it's saying that if somebody is sponsoring you, you have to prove that there is a genuine relationship between you and that person sponsoring you. That's a requirement. So if I'm able to prove that I don't have money, but the person sponsoring me is my aunt, my brother, or whoever, and there's that genuine relationship,
Mm-hmm.
and that eligibility requirement is met,
It's met.
why
Yeah.
will you then turn around to say that I don't think you will come back? And so it becomes a constitutional law matter that the decision by this caseworker is one, perverse, in that a rational caseworker cannot make the same decision, having been given the same information and the context.
Mm-hmm.
They may conclude differently. And therefore, this decision is irrational. This decision is harsh in a sense that it did not consider a whole range of other things. And on that basis, it defeats common law principle of fairness and justice. If that's the case, we've entered into the realm of constitutionality. Is this constitutional in a sense that a caseworker will go beyond the policy itself or will decide to interpret the policy in a way they feel it is to be interpreted because there is discretion for them. We are saying that that might be harsh. So what do we do? First, no admin review, no appeal. So what you do is to tell them that I have considered the decision and the decision is not fair for these reasons.
Mhm.
And that I want you to reconsider the decision. Once you do that, you are putting them on notice that because it's a constitutional matter, you are going to seek judicial review because you don't have right to administrative review or appeal.
Okay.
Judicial review is a constitutional matter when a public body makes an irrational decision or perverse decision or draws irrational conclusions. You go to the court for the court to review the decision and to ask them to remake it for you so that they conclude whether that decision should stand or should be reversed. And that's judicial review. So the visitor visa application, when it is refused, you can go for judicial review. No appeal, no admin review. How do
Okay.
you approach it? So you tell them by way of pre-action protocol letter that this is the situation, especially where there's nothing in it that is incriminating in terms of whatever application information presented by this person. So you tell the caseworker that we intend to pursue judicial review
Okay.
for the following reasons, and that they have to reconsider the decision. We have CPR, that's the Civil Procedure Rules. CPR 54 will tell you that once you put the person on notice, a letter before claim, the person has 14 days to respond. So you put them on notice, drawing their attention to the deadline, 14 days. They have to come back to you to say that we have received the notice and we are taking action. If they think they need more time, for example. So, producer, please share an example of a pre-action protocol note that has been sent. Just the first part, yes, only this part. So
Okay.
here we have made the caseworker aware that there's issue, and the issue is that the refusal is not fair. We move on to say that, so just down a little, background information. Yes, please down. Giving the background information, and that is end of it. Please go. If you can leave this part. So yeah, just move up. Yeah, thank you. Stay there. So we tell them this, and they have to come back within 14 days. So sometimes it takes longer than usual, but yours is to tell them that you are taking action on that basis. We move on to the response. What did they say? Producer, please. So 3rd October, they come back to say that you wrote to us da 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 da. You allege this, and that. You allege also that the decision is perverse. Move on down. You have asked the Secretary of State to do the following, and our response is that the Secretary of State has reviewed the decision and that it is proceeding to reconsider. However, we'll need more time and we'll come to you 3rd of January 2025.
So that's a long time from now.
Very good. Now, the person was refused, and this is the response to the challenge, initial challenge, because this is a judicial review route. Now, if you are going to wait for them to come back, that will be more than 90 days from the date of the decision,
That's right.
refusal
Yeah.
decision. And they know that regardless of whether they come back or they don't come back, the law is that if you want to seek judicial review, do it within 90 days. So 3rd of January, you don't wait for them. So this one, next week we are putting in something to let them know that this is it. So once you go judicial review, you have to now know that you've entered a higher realm, for that is upper tribunal matter. You have to have your facts right. You must have your argument solid, and you have to support with your evidence. You then make an application to go to the upper tribunal for them to review this decision that, in your view, is harsh or is perverse. Once they make their decision, they may say yes or no. If they say yes or no, they will give you opportunity to go further. So the first stage is book review. Let's call it no oral hearing. So the judge will review the evidence and the argument and say that the decision should stand or the decision should be reversed. If the judge says the decision should stand, it may be the case that you will not agree with the judge. So you have another opportunity to seek another application to go for oral hearing, where you'll be called to speak and to explain why you think your application should be considered should be reconsidered. At the oral hearing, once the decision is made to say no, you have a choice to still go further, which is Court of Appeal. After Court of Appeal, you can move on to the next, which is Supreme Court. I mean, if you have the means, the time, and everything else, you can go through the layers. However, the bottom line is that if you are refused a visitor's visa and you are told that you don't have right of appeal or you don't have right to administrative review, you can still challenge if you conclude that the refusal reasons are not clear or they don't make sense to you.
Let me go to this document that you showed us. The pre-action protocol and the response they gave. There was a bit that if we could have that on the screen so we can make reference to that. The response, yeah. Let's scroll down. Not the background facts. The response. The response, yeah. Yeah, please go down. Please go down a bit. Yes, response to matters raised. The Secretary of State has reviewed the decision to refuse the entry clearance application and will now proceed to reconsider the matter in the light of representations you have made and given the timeline. Number 6 says the Secretary of State has considered your request and deems that a sufficient remedy has been provided. Therefore, the pre-action protocol is now considered to be concluded. However, if you wish to proceed to judicial review, the service address is as follows and all that. Does it mean that they are saying that there's nothing they can do about it, so you can take your matter up?
Well, this one says address for service of court papers.
Mm-hmm.
Now, you can see that if anybody is going to conclude, 6 and so if you look at 6 and also up,
Mm-hmm.
6 and 4
Yeah.
are inconsistent. You can't say that I'm considering and therefore give me up to January, and at the same time you tell me that you have concluded.
Yeah.
That's
That's why I was asking whether they
don't mean that they have finished.
Closed,
they're just citing
the
standard phraseology that if you wish to proceed, remember I told you that if you wait for them to come back, which is January, that will be too late.
Mm-hmm.
So you have to go ahead within 90 days. So they are telling you that if you wish to progress, go on. This is their service address. However, if you wish to, they shouldn't have said, therefore, the pre-action protocol is now considered to be concluded. It is not concluded. And this one is a cut and paste thing for general ones that would have been concluded. Remember, this one, they are saying that they haven't finished.
Mm-hmm.
If they have finished, this is how they cite it, that we have finished, so it's concluded. But if they haven't finished, they shouldn't have quoted this sentence. And therefore, this is a wrong sentence quoted. But it doesn't really matter whether it's wrong or it's not. They also make mistakes. We are not looking at that. What we are saying is that they have told you that they haven't finished. And therefore, if you still want to go ahead, you can go on. And they know that if you believe what they are saying and you don't do anything now, by the time they come back, if they come back to say no, you can't progress because that will be more than 90 days.
Yeah. And
Is to count your
yeah.
time and do what you have to do. But
So
the
would you
six,
would you have to wait for around about 14 days from when they gave their response to act again or proceed to your next action?
you have 90 days from the date the refusal letter was given to you,
Hmm.
not the PAP response.
Oh, okay.
Yeah. If there was judicial administrative review, then your 90 days will start from the date of administrative review.
Okay.
But there's no administrative review. So this is a judicial review from the start. And the starting date or point is the date of the refusal
The
letter.
refusal. Okay. All right. So yes, Lawyer Asma has explained to us that yes, you can challenge that decision, and the most important and critical thing you need to do is to issue a pre-action protocol threat. If in the ordinary person's parlance that's correct, then they will respond, and then when they respond, you have the chance to proceed from there. Um, it might sound a bit naive, but let me ask. If you're proceeding from there, what do you do? Do you prepare your papers and go to court? Or you write to them to say that change your decision because I believe that you were wrong?
Yeah. Come again, please.
Yeah, what I mean is when you have received a response like they have given you, what particular thing do you have to do after that?
You have to ask yourself whether I'm within 90 days or I have to wait till 90 days because I have up to 90 days from the
Okay.
date of decision. So you don't have to wait. You can make your next move. The most important thing is that you've told them that you want to take action.
What will be
They
the
can
next
turn
move?
around and tell you that hang on, but we said that give us up to 3rd of January. But
Mhm.
then you also can tell them that 3rd of January would have been me losing my right to judicial review. Because that would be more than 90 days. So there was no need to wait for you.
Okay. And what particularly do you have to do next? Um, do you go to court straight away?
You apply for you apply to the court of appeal for administrative review for this decision to be reviewed by the court.
Okay.
And here you have to apply by making an application, completing the necessary application form. You have to add your reasons why you want the court to review the decision. You add the decision and you add your evidence, including a range of representations, and you file your papers with the court and you wait for the court to come back to you.
Okay. Now I'm looking at a person who's applying as a visitor to come for a particular event here in the UK. And they'll put in the application, say about a couple of months before the event. That's refused. We're looking at some timelines here. If by the time you issue your pre-action protocol, they respond and you apply to the Court of Appeal for them to do the administrative review and all that, that event that you wanted to attend would have come and gone. In that case, isn't that a waste of time?
Yes, that would be a waste of time. Of course, the court can then say that, all right, regardless of the conclusion or decision, the event is over anyway, and therefore, um, yeah, it doesn't really um, cause much pain to you, even if the decision is maintained. However, if you are to visit family, then it's not an event which can never be attended to at a future date. And
Mhm.
so the court will have reason to make a decision on that so that you can visit your friends or family at a future date. And so it's a matter of a decision or
Mhm.
judgment call for the applicant. If you want to prove a point, you can prove a point. But if you feel that your rights are genuinely trampled upon, then it's always advisable to pursue, especially those that fall within the human rights. There's a case law, the case of Al Hassan, KF Syria, for example, says that anytime a decision is made and a decision borders on human rights, it borders on Article 8, yes, right to family life, the court will have to consider the right of the family members involved. And so, if the visitor's visa application is to do with family visit, then the applicant has good reason to pursue a claim like this. The only thing is that it's very time consuming and expensive venture. So you have to be sure that you really want to do this. And also you have to make sure that you engage a lawyer to be able to fight this. Or you can see that most of the things we are talking about are of technical nature. You can even miss the deadline or a step, and that will go against you. So it's not just a simple application that you put in to say that after all, anybody can apply, and so let me do it. This is a different ball game altogether. Our advice that yes, you can assert your right by fighting a refusal of your visitor's visa application. However, you have to make sure that you do it through a lawyer. The first thing is to seek advice whether you have case to pursue.
The first thing is to seek advice, consult a lawyer and a legal person who knows what they are doing. BWF Solicitors is one I will greatly and highly recommend. 0208 493 7340. Remember, they have an office back in Ghana, and you can call them in Ghana on 055 589 5959. For emergency situations, call 004477 let me take that number again. 077-127-61884. 077-127-61884. And you can reach out to 𝗖𝗢𝗠𝗠𝗨𝗡 on 07947-636037. 07947-636037. BWF Solicitors, 4th floor of the other house, 214 to 218 on the Tottenham High Road, Seven Sisters. If you're coming by public transport, get onto the Victoria line, get off at Seven Sisters, use exit number 2, and that brings you to the frontage of the Anna House. Climb up to the 4th floor and you find BWF Solicitors. If you're driving, the postcode is N15-4NP. N15-4NP. BWF Solicitors are trusted partners. We'll be right back.
Based in London, we are a dynamic award-winning firm specializing in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specializing in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
BWF solicitors, thank you. We're still live on BWTV and we are streaming at BWF Solicitors Facebook, at BWF Solicitors YouTube, at BWF Solicitors BWTV Facebook, BWTV YouTube as well. So you can leave your comments in the comment section both on Facebook and YouTube. We'll pick that one up. Earlier on, I gave you the nugget, and it was this that applications for fee waiver are only intended for those making human rights applications. If someone makes a fee waiver application where they have no intention of making future human rights applications, it may constitute false representation. False representations represent a general ground of refusal in immigration decisions, and as such, there can be serious consequences for an applicant if they are found to have made such representations. Paragraph 9.7.1, Part 9 of immigration rules is what we have quoted. If you have any question, you can text that to me on and both WhatsApp and normal text 07399208468, 07399208468. And when the lines are active, you can call us on 0208 493 7345, 0208 493 7345. And before I take your questions, concerns, I have this question and a scenario for you. Let's help brother Nana McBrown. Nana McBrown came to the UK on a certificate of sponsorship as a healthcare worker for Abacus Limited. Abacus sponsor license was revoked. Nana McBrown was given 60 days to make another application or leave the UK. Nana applied for another certificate of sponsorship, but his new employer told him it would take 3 months to receive a decision. He was advised to apply for a fee waiver to buy time. He subsequently applied for another leave as a skilled worker with a new certificate of sponsorship. His application was refused for making a false fee waiver application when he never had an intention of applying for a human rights claim. Question is, why was Nana's application refused? His 60 days had passed. Fee waivers are for human rights applications, and he never had the intention of making a human rights claim, or the new certificate of sponsorship is false. Think about that. But then let's go back to a resource person. I guess this afternoon, Lawyer Charles Asma. I've got his number on the screen. After the program, you can contact him. He would be so glad to help you. 07947 He has taken us through the discussion and has made us know that we can challenge a UK visa refusal decision. Okay, now let's pick up. The lines are active, yes. You have a question about our topic, you can call in. If you want to ask any other legal question, lawyer is here and he will help you with that. 0208 493 7345. Or you can send a text, WhatsApp to 07399208468. A couple of them on the platform. Those of you who are on the platform, yes, thank you very much for being there. And I believe that you're enjoying it. Please ask people to come around as well. Now, your royalty. You're saying you're a student on a visa and it expires November 2024, which is next month. You're currently married and want to apply for a fee waiver for spousal visa. But your fear is that if the fee waiver gets rejected, you'll not be able to go back and apply for a graduate visa. So you caught up in the conundrum whether to do a fee waiver. You don't know your fate about that. If that's refused, because it may be seen as you made a representation, you are scared that you may not be able to go back to apply for a graduate visa. Like, is there any help we can give our dear sister?
So, did she say she's completed the course?
No, she didn't. She says the visa expires November 2024.
But has she completed the course?
She didn't tell us.
So we can't answer the question whether she can even do graduate study or put in a graduate study postgraduate study application at all. But that is for those who have completed their course.
Okay.
So we don't have sufficient information to respond to the first part. So I'll move on to the second part. The second part is if fee waiver is rejected, what do I do? If your fee waiver is rejected, pay and make the human right application. That is your spousal application. Your third question, more or less, is should I go for spousal application or I should go for graduate or can I go back to graduate? As for the graduate, we can't really tell whether you meet the requirement in the first place. But let's assume that you meet the requirement. If you do meet the requirement, why don't you put in the graduate route application? Because once you're on a graduate route visa, you can always switch to family life visa if your husband decide to sponsor your application for family route, or you have saved enough to be able to make a human right application. So either way, if you have opportunity for graduate, then nobody can tell you what you must do because that is a factual matter for you. However, in terms of the law allows people to apply if they qualify under the postgraduate study visas. And whilst they are on the postgraduate study visa, the law allows them to switch to any other route. And if one route, such as family life, has become apparent for you, you can switch to that when you know that you have the means and you meet the requirements.
Okay. Greetings to Oroku and Lawyer Charles. Namaiti, greetings to you as well. I know your birthday month is gone, but he's still in the mood, so continue enjoying it. Let's move on to this one. I've submitted an application for naturalization. I was asked to provide details of my previous applications, both in the UK and abroad. I provided details of my entry clearance extension in the UK and indefinite. Today's discussion has minded me about visit visa applied for a long time ago that was refused. This refusal was disclosed in all subsequent applications except the naturalization. Generally, I forgot to include it. Can this affect the decision? I met all requirements before applications, lawyer.
So the question will be, have you ever been refused a visa before? That's the question. And the answer, Bragoku, from this information, would the answer be yes or no?
Yes, they have been refused before.
And he
So
didn't
you should
disclose.
clear it, yeah.
That's false representation. And he will be, yeah, the application will be refused under suitability.
Wow. And it must be a genuine mistake.
Well, we all make genuine mistakes, but the intention cannot be seen from the genuineness. If he feels that he wants to preempt the decision, he can write to them to say that I applied and I did not seek legal support. Upon the application, I discussed my situation with a lawyer, and the lawyer probed more. And I remembered that I forgot to make a disclosure. I told the lawyer about it, and the lawyer said that I should have done that. I'm now writing to say that this was not intended, was a genuine omission, and that it is true that XYZ, you give the details and leave them to make a decision. And even if they make a decision without considering this letter that you've sent to them, if you are going to challenge the refusal of the naturalization application, you can cite the fact that I came back when I remembered. And if it was intention to deceive you, I wouldn't have come back to you
Have done that, yeah.
when I remembered.
Okay.
That's a way to mitigate that.
Okay, all right. Yes, if you would want to call us 0208-493-7345, send a text or voice note to 07399208468. Now let's pick up a few of those comments. Nana Safo on YouTube says, how long do I take from, or does it take, I think that's what you mean, for the Home Office to make a decision on parenthood based on her British child?
Right. The rules say that caseworkers have 12 months plus to make the decision. 12 months plus.
Mm-hmm.
However, sometimes it is earlier than usual. So you can but because this is a fixed question, the fixed answer is 12 plus months.
Okay, 12 months plus. Thank you. We keep them coming through. We have a couple of them. Also, my UK UKV cars account, so to speak, and I think we had an update to say that their contract has been given to TLS contract, and between now and the 15th of October, they're not processing biometrics. The tab for upload is still active. How can I send additional information? If I upload a letter of explanation and send to UKV cars, will they send it to UKVI automatically, or I have to book an appointment with them to go there? I think it relates to the previous question where he forgot to provide a detail that he had been refused a visa some time back.
Yes, so yes, you can add the letter and prepare the letter and upload it. Even though you've done your biometric and all that, as you said, the link will still your portal will still be active, so you can update with new information. We just expect that they would have not picked what is already there up already. If not, then when they are picking the document up, this will be picked up as well. I will also suggest, this is not an advice, I will suggest to you that in addition to uploading, find an email and send them an email with that attachment to them so that you cover all grounds. And you are thinking that if something may come up in future that you have to challenge the naturalization, then you took all reasonable steps to remedy the omission, what we call the common sense approach or the objective bystander approach.
Yes, we're still active. Your calls are invited. 0208-493-7345. You can leave your question or a comment as people are doing in the comment section down below, both on Facebook and YouTube. As an NHS employee in the hospital, how long do you have to wait after submitting your visa renewal application before applying for the IHS refund?
Right. You can immediately make application for refund because the refund process takes time. So start early.
Okay. A stitch in time, they say, saves 9. So lawyer has advised start early. It could take time. I gave birth here in the UK, lawyer, but I've not been sent the NHS bill. Can I still apply for my visa on the 5-year family route?
I gave birth in the UK whilst he didn't have leave to remain. Is that what you mean? We don't have enough information. But I have not been sent a bill. Did you have to pay a bill and that it hasn't been sent and you're expecting the bill to come through? We don't have enough information. Can I still apply for my visa on the 5-year route? If you qualify for a visa on the 5-year route, please go ahead and apply. But regarding the first two, I don't have enough information, so I cannot conclusively respond to the first two parts.
Okay. Yes, your questions, comments, your contributions in the comment section. Good afternoon, please. Can the Home Office appeal against the court decision in your favor? I think obviously they can they, lawyer?
Yes, just as you have a right to appeal against court decision in favor of the Home Office, they also have a right. And that application, which is onward appeal, will go to upper tribunal. So you seek permission from the first tier tribunal to grant you permission to go to upper tribunal with your appeal. If they refuse, you go to upper tribunal to seek permission. If they grant, you are okay. If they refuse, then they have refused it. So by your question is clear, and the answer is yes.
Yes, you can. And you're getting all the answers, the explanation, and the tactics from the law firm we can really trust. Our resource person, our guest this afternoon is Lawyer Charles Asma. What's the WhatsApp number? Yes, 07399208468. 07399208468. The landline is also active, 0208-493-7345. So if you want to call, you can call either of them and we will get Lawyer to respond to you as well. If you would want to send a voice note as well, yes, Lawyer's here and he will do justice to that as well. The topic we have discussed this afternoon is whether you would be able to appeal against or challenge the Home Office visit visa refusal decision. The answer is yes, you can. And Lawyer Chazasma is giving us a scenario where you can do that and how you can go about it. Later on, before we draw the curtains down, he'll give an explanation of a summary, so to speak, of that. Can I use ISE1 integrated skills in English, the CEFR level B1 for healthcare assistant visa application? Wow.
Integrated skills in English, B1 for healthcare. Well, there are so many English language routes or English language assessment. What I B yeah B1 is a higher threshold, but B1 may not necessarily be for health care route. So if you are making an application as skilled worker on this route, please, when you are booking for your English language, tell them specifically that this is for health and care visa, so that they tailor your assessment to that particular visa.
Well, keep your comments coming through. Keep your text coming through. Text number 0739920848. WhatsApp 0739920848. Landline 0208-493-7345. Is there an alternative option for life in the UK test on the 5-year route? David is asking, Lawyer.
Another 5-year route, there's no life in the UK. There's only English language. Life in the UK is for for indefinite leave to remain and naturalization only.
Okay. Well, so David, yes, you don't need that. So that get your English language passed, and you will be fine with that. I was given 60 days to leave the UK since my company's license was revoked after delivery. So I had to do an application for a parent of a British child at a priority service before the 60 days exhausted, whereby my child B book application was in, but yet not approved. Now the British book is being denied, but no reply from Efikasim, that's Home Office, they want to me, on my application. What application can I do now if I'm refused on the parent application, or should I withdraw it now before any decision, Lawyer?
Thank you very much. Lalitha. Let's break your story down. 60 days. Had to make an application for parent of a British child, priority service before 60 days, whereby my child was B book application was in, but yet not approved. Now the B book is being denied, but no reply on my application. What application? All right. Okay. So what happens is that if they request for you to provide proof of the child's British citizenship, of course, you would need the B book, which is the British book, I suppose, or the British passport. Now, there are two things here. There is operation of law, which is Section 1 of the British Nationality Act, which is enshrined in that if a child is born to a British parent, the child is British from date of birth. If the child is still under 18 years at the time, so it's still a child. So in this case, this is your child where you are worried about he or she doesn't have a British passport. But the question is, passport does not define citizenship. Passport is a travel document. You choose to have it if you want to have it. And so not having a passport does not make you a non-citizen. And so if you're able to prove that at the time my child was born, the father was British, and this is the evidence, then your child is British, whether there's B passport or no B book or no B book. If your visa is refused because they can't tell that your child is British and therefore it's a qualifying child, you use the same law to remind them that my child is British because at the date of birth, my child father was British and I was not married to anybody. And so my child is. Then you use the law to explain the circumstance and why it should be granted. And you can challenge them by going for administrative review. If you are not given, you can appeal, or you can even move on further on if you have to. So I don't think you have to worry so much as to withdraw your application. Wait for them to make the decision and you know what to do. If you're still in unsure and you want to discuss in detail, feel free to get in touch.
Feel free to get in touch. You can call Loyaltos Asthma on 07947636037 or contact BWF Solicitor 0208-493-7340, emergency 077-127-61884. Let me bring the nugget again and my scenario. Then we will go to our quiz segment where I'll ask you to help Nana McBrown. Applications for fee waiver are only intended for those making human rights applications. If someone makes a fee waiver application where they have no intention of making future human rights applications, it may constitute false representation. False representations represent a general ground of refusal in immigration decisions, and as such, there can be serious consequences for an applicant if they are found to have made such representations. Okay, with this as the background, our friend Nana McBrown is facing a big decision he has to make. He would want to understand why his application has been refused. Now, let's look at a scenario. He came to the UK on a certificate of sponsorship as a healthcare worker for Abacus Limited. Now, this Abacus Limited has their sponsor license revoked. Nana McBrown was given 60 days to make another application or leave the UK. He applied for another certificate of sponsorship, but his new employer told him that it would take 3 months to receive a decision. He was advised to apply for a fee waiver to buy time. He subsequently applied for another leave as a skilled worker with a new certificate of sponsorship. His application was refused for making a false fee waiver application when he never had an intention of applying for a human rights claim. Why was his application refused? Is it because the 60 days had passed? Is it because fee waivers are for human rights applicants and he never had the intention of making a human rights claim? Or the new COS of the certificate of sponsorship was false? What answer would you give, my friend Nana McBrown? I will come back to pick your answers after this break. Okay, we're back. Let's see what answers you have given me. I have taken you through the nugget that forms the basis of this scenario. If someone makes a fee waiver application where they have no intention of making future rights applications, it may constitute false representation. Now, what about false representations? It's for people not providing the correct answers. And in the ordinary person's parlance, it's like you've lied to the Home Office. And they represent a general ground of refusal in immigration decisions, and as such, there can be serious consequences for such an applicant if they are found to have made false representations. Okay, now let's see what answers you have to Nana McBrown. His 60 days passed, that's why his application was refused. Fee waivers are for human rights applicants, and he never had the intention of making one. The new COS is false. Well, the first answer was two. Doris also says it's two. So if they give someone 60 days to leave the country and he or she is still staying in the country doing cash in hand job, what will happen? Anyway, when that comes up, I'll get him to answer this question for us. Let's see the other. Kevin says number two. Okay. 𝗖𝗢𝗠𝗨𝗡𝗜𝗧𝗬, this is because his intention of applying for a fee waiver was to buy time for the new COS application, which he was told it would take 3 months before a decision would be made. So, well, that's why he was refused. Okay. Doreen Kusi says the answer is number two. Number two seems to be very popular. Okay, let's see. Who else? Osetu says number two. Thank you, OT. The next one says Prince Asamoah says number two. That's about that as well. Let's go on to John Saki. John Saki says number two. Fee waivers are for human rights applicants, and he never had the intention of making a human rights claim. Okay? All right. Who else? 𝗖𝗢𝗠𝗠𝗨𝗡𝗜𝗧𝗬, sorry. I choose number two. You choose number two. You should be certain. Once the application is not yet decided for the past 6 months, can I also submit my application as partner using the British child as a stepchild? Okay, then that's what a follow-up to your question the lawyer answered earlier on. Okay, now let's see. Lawyer, people say it's number two.
So what we're going to do is to break it down. I know we have limited time, but we'll do it in 3 minutes. So we break it down, and the answer will emerge naturally.
Mm-hmm.
First, we know Nana's circumstance. 60 days to apply for another visa. They didn't say this visa, that visa, or this. It says make another application, you have 60 days.
Mm-hmm.
Nana decides that, okay, I'm going to make a human rights application, but I cannot afford. So I want a fee waiver. Because fee waiver is only for human rights applications, not worker applications or skilled worker application. Now, Nana makes the application, fee waiver is rejected, or whatever the case, fee waiver application is made, and within that bit, or even after the 60 days, the fee waiver, while the fee waiver is pending, let's assume that the fee waiver decision is made and it's rejected. He has to go ahead to apply for the human rights application and pay for it. If it is not rejected, he has to pay, he has to use the code and apply. Did Nana make the human rights application from the story? Did he do that?
No, it wasn't stated. He didn't.
He didn't. So there are 2 reasons for fee waiver. Either you do it to make it appear as if you are going to do a human rights application with a view to protect your leave, or you do it so that you make a human rights application for people who are genuine.
Mm-hmm.
Nana's case, it appears that there was no intention for a human rights application, but just to protect the visa itself. Because we are told that whilst the human rights application is not made, he makes a skilled worker application with a new sponsorship certificate. And the sponsorship certificate and then the skilled worker application is refused. The question here is, they didn't even tell us he's refused because of this or that. They simply said that he's being refused because suitability is not met.
Mm-hmm.
Why? Why would he apply for a fee waiver if he knew that the only application he's waiting for is a skilled worker application? What could be the intention?
And you were buying time.
To deceive, isn't it? Maybe
Yeah.
just playing games. If you are playing games, they think you are diabolical. But if you go ahead to make the application as you wanted to, then you are fine. Once the application is not decided, you can vary the application by making a skilled worker application. In this case, they will say that your fee waiver was intended for something else. You then challenge them to say that no, it was intended for human rights. That's why I went ahead to make my human right application. And because of that, the application will be refused simply because he played the game too.
Okay. So the number two, that was the popular answer, is correct. A few of us lawyers said it for human rights applications and not for those intending to apply under the skilled worker route, as this route does not have a fee waiver available. Suitability requirements include SW 2.1. The applicant must not fall for refusal under Part 9 grounds of refusal. And with that, thank you very much for participating. Thank you very much. But before we go, let's see what we discussed as lawyer Asma summarizes.
Thank you very much, viewers and listeners, once again for your time. Today, we have made you aware that once your visitor's visa application has been refused, even though you don't have right to appeal or right to administrative review, you have right to judicial review. This is because the decision could be seen to be perverse or harsh, irrational, common, non-commonsensical, and as a result, you want the court to review that decision. So once your visa is refused, even though it's a visitor's visa application, if you feel that the decision is not fair, you can apply to the court for judicial review. Before that, you have to make an application. You have to send a letter to the Secretary of State or the Home Office telling the caseworker that you intend for them to review your decision because you are going to court. Once they have that letter, they will review the decision automatically and change their mind or maintain it. Within that, you have 90 days to go to court. So make sure that from the date of the refusal, counting 90 days, you go to court requesting a review by the court. What does it entail? Simply telling the court that they should consider the decision and tell you whether it is fair or not fair. You must add a legal argument, what we call grounds. You have to complete a standard application for judicial review. That will go to the upper tribunal, and it's also done online. And therefore, it is something that you will need a lawyer for. But in all circumstances, once this has happened to you, please don't give up if you feel that you have a case to challenge the Secretary of State on. This is what we've covered. Thank you.
And with that, I would want to say thank you very much to everybody that's taken part in today's discussion. You have stayed for 2 hours, and that's so wonderfully appreciated. Thank you very much. And to Lawyer Charles Asma, thank you for your time. Thank you for your patience and sharing knowledge with us as well. And to BWF solicitors, we want to say we salute you, and we will continue to come back to you to help us educate the community as far as our legal matters are concerned. And of course, once you have been touted as our trusted legal partners, we will come to you. Contact BWF Solicitors 0208 493 7340 or 077 127 61884. To our viewers, I want to extend another invitation to you because we'll be back again same time next week on the platforms BWF Solicitors on Facebook, YouTube, BWTV on Facebook, YouTube. To my studio producer, Professor Day, thank you for being there all the time and being so reliable. To Padma Dodu and Sheila Ankra for the aesthetics, and to Pamela for that wonderful feat you have achieved. You have chalked another milestone in your life. You are a year older, and may the years ahead of you be graceful, be full of successes, and may you be what you want to be. My name is 𝗖𝗢𝗠𝗨𝗡𝗓𝗧. Good evening.